Hello learners, my name is Dr. Leah Kaler, and today we are going to be talking about criminal forensic assessment. So forensic assessment are specialized psychological evaluations conducted to provide information that's relevant to legal proceedings. These assessments help the court make informed decisions on various legal issues. There are some types of forensic assessments used in court proceedings, so we are just very briefly going to talk about lots of different ones today. Just know that this is what we have in store for the rest of the semester and start to get excited. First and foremost is competency to stand trial. This determines whether a defendant has the mental capacity to understand the charges against them and can assist in their defense. Some key elements for assessing the defendant's ability to comprehend legal proceedings, communicate with their attorney, and make decisions about their case. Criminal responsibility, you may also see this called insanity defense. This evaluates whether a defendant was legally sane or insane at the time of their crime, meaning that they could, if they were insane, they were not able to understand the wrongfulness of their actions or conform their behavior to the law. When we're doing assessments such as these, the defendant's mental state at the time of the offense, including psychiatric disorders or cognitive impairments, are going to be of key importance. Risk assessment, these are estimates of the likelihood that the individual will engage in future violent or criminal behavior. Here we're going to be using various different structured tools and clinical judgment to evaluate risk factors such as past behavior, mental health status, and environmental influences. Perhaps maybe we're doing a child custody evaluation, where we are assessing the best interests of the child in custody disputes, including parental fitness and the child's needs. Evaluation of each parent's ability to care for the child's relationship to each parent will be relevant, and potentially any other psychological factors. Maybe we are asked to do an evaluation of psychological evaluation for sentencing. And this provides the court with information on the defendant's psychological state to inform sentencing decisions. This may include assessments of mental illness, cognitive impairments, personality disorders, and any mitigating factors that may influence sentencing. We talked about risk assessment before, but we could also be doing risk assessment specifically for violence. Whenever we're doing this determines the potential of violence risk posed by a person, often in cases including or involving parole, probation, or civil commitment. Some factors we may be looking at are previous violent behavior, substance abuse, mental health issues, and situational triggers. Similarly, we talked about child custody, but circling back to that, maybe parental fitness evaluations. We want to assess whether a parent is psychologically and emotionally capable of providing adequate care for the child. We may be evaluating the parent's mental health, their parenting practices, and abilities to meet the child's needs. Perhaps we are looking at juvenile transfer evaluations to determine whether a juvenile should be tried as an adult or remain within the juvenile justice system. Here we may be looking at the juvenile's maturity, their mental health, their risk for reoffending, and how amenable they may be to rehabilitation. Some other evaluations that we maybe don't think of off the top of our head would be disability evaluations and competency evaluations. So when we're looking at this, the individual's mental and cognitive abilities in the context of disability or even guardianship proceedings will come into play. We're going to assess intellectual functioning, decisional making capacity, and the need for a guardian or some type of special accommodation. We also may be asked by the court to do some type of personal injury or trauma assessment, where we're looking at the psychological impact of injuries or traumatic events. Often this will be seen in more of a civil litigation, and evaluations such as these will particularly be looking at PTSD, depression, anxiety, and a connection to the event in question. We may also be looking at capital cases, and we may want to look at mitigating circumstances. This may be a question of the court. So perhaps we're assessing psychological factors. They may mitigate a defendant's culpability in capital cases, influencing sentencing decisions, death penalty versus life imprisonment, things like that. These evaluations will definitely include mental illness, developmental disorders, and the impact of past trauma or abuse. Lastly, we're just going to touch upon capacity to waive Miranda rights, and the purpose of this is to evaluate whether a defendant had the cognitive or psychological capacity to understand and voluntarily waive their Miranda rights. The assessment of that understanding of their rights and the implications of waiving them, and the voluntariness of the decision. A psychological case becomes forensic in nature when it involves the intersection of psychology and the mental health system and the legal system, meaning that a psychological assessment, treatment, or evaluation is being conducted for legal purposes rather than solely for therapeutic or clinical reasons. And this includes everything that we've been talking about so far. So, a few things that I want to mention here are that psychological treatment provided to individuals under court order, such as mandated therapy for offenders, perhaps sex offender treatment, or substance abuse programs that can be part of a legal sentence. Also, psychologists may provide services within correctional settings where the primary focus is on legal and institutional issues rather than solely therapeutic goals. Some other things that we may be doing as forensic psychologists could be conducting assessments to determine if an individual is exaggerating or faking psychological symptoms, often in cases where perhaps financial compensation or legal outcomes are at stake. Expert testimony is going to be a big piece for a forensic psychologist. When a psychologist is an expert witness, they offer opinions based on psychological evaluations that they have completed, and these evaluations are intended to assist the court in making a legal determination. So a psychological case becomes forensic when it involves the application of a psychological knowledge, method, practice to answer legal questions or to provide information relevant to legal proceedings. The focus shifts away from purely therapeutic or clinical concerns to issues that directly impact legal decisions, rights, and outcomes. This requires the psychologist to operate within the legal framework, adhering to specific legal standards, and often engaging with the legal system as part of their role. So here today, we are going to talk specifically about the specialty guidelines for forensic psychologists, and that they are intended to help guide our practice and help us when we are engaged in activities that involve application of psychological knowledge to legal matters. So let's talk a little bit about this. First and foremost, we've already been talking about it. It's the name of the course, Forensic Evaluations. When conducting psychological assessments or evaluations for legal processes, such as competency to stand trial, child custody evaluations, or risk assessments for violence, this is going to be huge for a forensic psychologist and very much when we should be looking to our guidelines for assistance. Also, expert testimony. When we are providing expert testimony in legal settings, there is a psychologist's opinion, and it will be used to inform the court on matters such as mental health, criminal responsibility, or other psychological issues. Psychologists may also be hired for consultation when legal professionals need us. So that could be attorneys, judges, law enforcement, anywhere where psychological expertise is applied to help understanding psychological aspects of a case. Treatment in forensic settings. When providing psychological treatment to individuals within the legal system, such as offenders in correctional facilities, or when treatment is mandated by a court order. Also, too, I think we forget about this point, but research in forensic psychology. When we are conducting research that's directly relevant to forensic psychology, or may be used in legal contexts, including studies on like risk assessment tools or interrogation techniques or psychological profiling, this is really where our specialty guidelines can come into play. Also, education and training, exactly what we're doing right here, right now, when involved in education and training of future forensic psychologists, and where the teaching or supervision of activities that includes forensic psychology, content, or practice. Last but certainly not least, interacting with the legal system. Any scenario where a psychologist interacts with the legal system, including but not limited to law enforcement, courts, or other legal entities. So these specialty guidelines are really practiced and applicable regardless of whether the psychologist is working directly in a forensic role or is performing tasks that may have forensic implications, such as clinical work with patients involved in the legal system. These guidelines really provide a framework for ensuring that the psychologist's work adheres to ethical and legal professional standards specific to forensic psychologists. So one of the questions here is the psychologist, or is the term forensic psychologist, proprietary? No, forensic psychologist is not a proprietary term. It is a professional designation used for psychologists who apply their expertise to psychology to legal matters. Forensic psychologists are typically involved in a variety of legal settings, including criminal cases, civil litigation, family law, and other areas where psychological knowledge is relevant to legal issues. So a couple of key points we want to talk about here when we're asking ourselves if this is a proprietary term is the professional title of forensic psychologist. It refers to a psychologist who has specialized training and experience in the application of psychology to legal issues. This can include evaluations, assessment, consultation, and expert testimony. While the term itself is not proprietary, practicing as a forensic psychologist usually requires appropriate licensure as a psychologist in the jurisdiction where they work. Additionally, many psychologists choose to seek board certification in forensic psychology through organizations such as the American Board of Professional Psychology. So if you see the letters after someone's name, ABPP, that means that they have pursued this additional certification through the American Board of Professional Psychology to designate themselves as an expert in forensic psychology. The term forensic psychologist is commonly used in a professional, academic, or legal context to describe the specific area of practice within psychology. However, it's not trademarked or owned by any particular entity. And forensic psychologists must also adhere to specific ethical guidelines, such as those provided by the APA, the American Psychological Association, and we have to operate within that framework that is relevant to us. So in summary, forensic psychologist is a widely recognized and professionally designated term rather than any type of proprietary term. It signifies a specialization within the broader field of psychology, focusing on the intersection of psychological practice and the legal system. So here, this is just a sneak peek for what we are going to see the rest of the semester. I hope you are just as excited for this course as I am. We're going to have a great time together, and there's a lot of excellent things that I have in store for you. So we briefly touched upon these at the beginning, and we are going to see them much, much more throughout the semester, so we're not going to spend too much time here today. Next, we need to talk about the nexus between the mental state and the legally relevant behavior. And this is the connection or the link between the person's psychological condition, so their mental state, and their actions that are subjected to legal scrutiny, or you may also hear it called legally relevant behavior or forensically relevant behavior. We'll use those terms interchangeably throughout the semester. This concept is crucial in forensic psychology because it directly impacts legal decisions regarding criminal responsibility, competency, and other legal determinations. So some key aspects of the nexus between mental state and legally relevant behavior. First and foremost is criminal responsibility. We're going to talk about that one. So if we're talking about the insanity defense, the nexus is central to determining whether a defendant should be held criminally responsible for their actions. If a mental illness significantly impaired their ability to understand the nature of their actions or to distinguish from right and wrong, this could establish a nexus that supports an insanity defense. In criminal law, for a person to be found guilty, it must be proven that they had the necessary state of mind. You'll also hear this called mens rea or guilty mind, and they have to have a guilty mind or mens rea at the time of the crime. For example, whether they acted intentionally, knowingly, recklessly, or negligently. The forensic psychologist may evaluate whether a mental disorder affected the defendant's capacity to form the required mens rea. If we talk about competency to stand trial, the nexus is also important in determining whether a defendant is competent to stand trial. This involves assessing whether their current mental state allows them to understand the legal proceedings and to assist in their own defense. If a mental disorder is found to significantly impair these abilities, it can establish a nexus between the need to declare the defendant competent versus incompetent. If we're looking at diminished capacity, this is a legal defense that argues that the defendant's mental state was impaired, reducing their ability to form the intent required for a specific crime. Here, the nexus is established between the mental impairment and specific behavior in question, which leads to a lesser charge or a reduced sentence. You may often be asked to assess for dangerousness, assess for risk or future behavior. The nexus is also considered when evaluating the potential for future dangerousness. A forensic psychologist may assess whether the individual has a mental disorder that is likely to lead to a behavior that poses a risk to public safety, such as violent or criminal acts. This is often considered in parole hearings, sentencing, and civil commitment cases. We need to talk about causation as well. So with regard to direct causation, establishing a nexus involves demonstrating that the mental state directly caused or significantly contributed to the legally relevant behavior. For example, showing that a psychotic episode led to a violent act would establish a strong nexus. In cases where the mental state doesn't entirely excuse the behavior, so not being able to meet full criteria for insanity, for example, it might still serve as a mitigating factor that affects sentencing or other legal outcomes. And lastly, let's just touch upon civil cases. The nexus can also be relevant in civil cases, such as determining whether a mental illness contributed to negligent behavior that caused harm to others. For example, in personal injury cases, the mental state of the defendant might be assessed to determine liability. So, in summary, the nexus between the mental state and the legally relevant behavior is a critical concept in forensic psychology that connects the individual's psychological condition to their actions in a legal context. This connection is essential for determining criminal responsibility, competency to stand trial, applicability of legal defenses, like we just talked about, insanity, diminished capacity, and it also plays a role in risk assessment, sentencing, and civil liability. So, forensic psychologists are often tasked with evaluating this nexus to inform legal decisions and ensure that justice is administered fairly, taking into account the psychological factors that may be influencing behavior. So here you see that the role of the forensic psychologist is to assist the trier of fact. So what is the trier of fact? Well, the trier of fact refers to a person or group of people responsible for evaluating the evidence presented in a legal case and making a determination of fact. Depending upon the legal system and the type of case, the trier of fact could be a judge. In bench trials, the judge serves as the trier of fact, determining what happened based on the evidence and applying the law to those facts. It could also be a jury. In jury trials, jury members are the triers of fact. They listen to the evidence, assess the witness credibility, and make decisions about the facts of the case. So the role of the forensic psychologist in assisting the trier of fact is that we can provide expert testimony. We often serve as experts, providing testimony that explains psychological findings in ways that are more easily understood, and we may testify about the mental state of the defendant, the likelihood of future dangerousness, or the reliability of witness testimony, among many, many other things. We can also assist the trier of fact in the way in which we conduct assessments and evaluations relevant to legal questions at hand. Again, this could be competency to stand trial, criminal responsibility, risk for recidivism. The results of these evaluations are going to help the trier of fact make informed decisions about these types of cases. The forensic psychologist is also going to assist the trier of fact in understanding psychological concepts and diagnoses that may be relevant to the case. For example, they might explain how a particular mental disorder could influence a person's behavior or decision-making process. We also assess whether a defendant is competent to stand trial, meaning the defendant understands the nature of the legal proceedings and can assist in their own defense. The trier of fact will then use this information to determine whether the trial can proceed or if the defendant requires treatment or restoration before being tried. Forensic psychologists can also provide assessments that inform sentencing decisions, particularly in cases involving mental illness, risk of future offending, or need for rehabilitation. Their input can influence whether a defendant receives a prison sentence, perhaps psychiatric treatment, or some other form of intervention. In cases involving potential future danger, such as parole hearings or sexually violent predator cases, forensic psychologists assess the likelihood that an individual will reoffend. This information is critical for the trier of fact in deciding issues like parole eligibility or civil commitment. And then lastly, forensic psychologists can also provide insight into the credibility of witnesses or the reliability of memory, especially in cases involving children, trauma, or suggestibility. This helps the trier of fact weigh the evidence more accurately. Here on the slide, we also see some information about the level of competence. So here we see the, quote, reasonable degree of psychological certainty, unquote, and this applies to psychologists' conclusions that are based on sound, thorough, and scientifically grounded evaluations. It indicates that the psychologist is sufficiently confident in their findings to present them as reliable evidence in a legal setting. So when forensic psychologists testify, they're often asked to provide their opinions on various matters. Again, perhaps it's competency to stand trial, criminal responsibility, risk assessment, you name it. And to meet the, quote, reasonable standard of psychological certainty standard, the psychologist must ensure that their opinion is based on the best evidence and the best data and methodology available. So this phrase, reasonable degree of psychological certainty, it is analogous with the reasonable degree of medical certainty used by physicians or other medical experts in court. While there's no universally agreed upon percentage or probability that defines reasonable certainty, it is understood to be a high level of competence that is just below absolute certainty, acknowledging that there is always some degree of uncertainty in psychological and medical evaluations. The psychologist's conclusions must be based on established psychological principles, methods, and research. This means that the opinions provided should be consistent with professional standards and supported by empirical evidence or well-accepted clinical practices. This standard is important because it helps courts determine the reliability and admissibility of expert testimony. A psychologist who cannot meet this standard may have their testimony thrown out or may be given less weight by the judge or the jury. And lastly, psychologists are ethically obligated to provide an opinion that is honest, objective, and based in evidence. They must avoid overstepping the limits of their expertise and ensure that their conclusions meet the, quote, reasonable degree of psychological certainty standard to maintain the integrity of the legal process. So as we move to our next slide here, the clinical and forensic assessments, there's some similarities, but there are also a lot of differences. So here we are going to talk about some distinctions between clinical and forensic assessment, and we're going to compare the two. So with a clinical assessment, the primary goal is to diagnose and treat psychological disorders. Clinical assessments focus on understanding the individual's mental health to determine a treatment plan that promotes well-being and recovery. These assessments occur in healthcare settings such as hospitals, clinics, or private practices, where the focus is on the client's therapeutic needs. In contrast, forensic assessment, the main goal is to provide information that addresses the legal question or the legal issue. Forensic assessments are used to inform legal decisions, such as, again, we mentioned competency to stand trial is just one of many examples. And these assessments may take place in legal settings such as courts, correctional facilities, or forensic hospitals, and are focused on the legal implications of the individual's psychological state. we have to talk about the client relationship. In clinical assessment, the relationship between the clinician and the client is collaborative and supportive. The psychologist works with the client to help them understand their mental health and to develop a treatment plan. With regard to confidentiality, which this is also going to be very important, in a clinical assessment, confidentiality very much applies. Information disclosed in clinical assessments are generally confidential and shared only with the client or other healthcare providers involved in their care, unless there is a legal or ethical obligation to disclose, such as risk to self or others, or if the client signs some type of waiver to share this with another person. Now, in the forensic world, the relationship is more evaluative and less supportive. The forensic psychologist's primary obligation is to the legal system, not the individual being assessed. This is very important. The psychologist remains objective and impartial, as they are often appointed by the court or retained by one of the parties involved. With regard to confidentiality in the forensic assessment, the information obtained during a forensic assessment is typically shared by the court or legal parties involved. The individual being assessed is informed that their disclosures may not remain confidential and often do not, and they could be used in legal proceedings. Next, we need to talk about informed consent. Within the clinical assessment, informed consent involves explaining the purpose of the assessment, how the results will be used, maintaining confidentiality, and the focus is on the client's autonomy and understanding. Whereas in forensic assessment, the informed consent includes informing the individual about the nature and the purpose of the assessment, the major limitations on confidentiality, and how the results will be used in the legal proceedings. The individual is also made aware that the assessment is not for therapeutic purposes. Next, we're going to talk about the focus of the evaluation. Within the clinical realm, these assessments focus on diagnosing mental health conditions, understanding psychological functioning, and developing treatment plans. The assessment typically covers a broad range of psychological factors affecting one's well-being. Within the forensic assessment, these are narrowly focused on answering specific legal questions. For example, again, competency to stand trial, risk for reoffense, and the assessment is guided by legal standards relevant to the case. With regard to assessment methods, in clinical assessments, these are often involve a variety of methods, including clinical interviews, psychological testing, observation, and even sometimes medical evaluations. And the goal is to gather comprehensive information to understand the individual's psychological state. Now, within the forensic assessment, these are typically more structured and focus on specific legal criteria. Forensic psychologists may use standardized tests that are relevant to legal questions, and they often rely on collateral information such as legal records, third-party interviews to corroborate their findings. Let's talk about the outcomes and reports. Within clinical assessment, the outcome is usually a diagnosis and a treatment plan aimed at improving the individual's mental health. Reports are often written in a manner that is accessible to other healthcare providers and focused on the needs of the client. Whereas forensic assessment, the outcome is an opinion or recommendation that directly addresses the legal issue at hand. For forensic psychologists, and their reports are typically much more detailed, include a discussion of the evidence. They are written for a legal audience, such as a judge or a jury, and they are structured to explain how the findings relate to the legal standards and the questions. We would be remiss if we didn't talk about ethical considerations within the clinical setting. Ethical considerations in the clinical assessment focus all on promoting the well-being of the client, the confidentiality, and obtaining informed consent, whereas in the forensic setting, we as forensic psychologists must navigate dual roles and ensure that they maintain objectivity and impartiality. We must balance ethical obligations to the individual being assessed with our duties to the legal system, such as providing honest, accurate information that can be used in the court. So the examinee often does not have autonomy over their participation. Typically, whenever it comes to forensic assessments, the participation within the assessment is often mandatory. As we move on, the clinical context may not even consider malingering or impression management, but this is a big factor in forensic psychology, as people will want to paint themselves in a certain light that is favorable to the outcome that they want. There is a substantially greater likelihood of conscious distortion. We're going to talk much more about this in future lectures and how we handle malingering and impression management. The legal system and the court proceedings may be very, very fast-paced due to court schedules, limited resources, and other external factors are all contributing to this. And despite it being so fast-paced, we need to highlight the importance of accuracy because of the very, very high stakes of legal decisions. Forensic psychologists are tasked with providing objective, unbiased assessments and evaluations for the court. Unlike clinical psychologists, the primary role is not to provide therapy, but to offer expert opinions based on our evaluations. We have to maintain neutrality and avoid forming a therapeutic alliance with the defendant. Before conducting any assessment, the forensic psychologist must obtain informed consent from that person. This includes explaining the nature of the evaluation, its purpose, and how its findings will be used in the legal context. It's crucial that the defendant understands the psychologist's role is not to provide personal therapy, but to offer an expert opinion to the court. Forensic psychologists must clarify that they will maintain confidentiality. Any information that forensic psychologists have to clarify that with regard to confidentiality, anything may be disclosed in court. And so this transparency helps to manage the defendant's expectations whenever it comes to privacy or the information in which they are sharing. The forensic psychologist's relationship with the defendant is characterized by objectivity, clear communication, and strict adherence to legal and ethical standards. The professional relationship is crucial to ensuring the psychologist's findings are credible and useful in the legal process. The relationship between the forensic psychologist and the defendant is governed by several key legal and ethical principles, but it does not fall under traditional forms of privilege, such as attorney-client privilege or client-therapist privilege. So we want to highlight that there is no therapeutic privilege when the forensic psychologist is working with the defendant, and the forensic psychologist's role is not to provide therapy, but to conduct an assessment for legal purposes. Therefore, the standard therapist-client privilege does not apply. We need to make sure that we very much highlight this, because in regular therapy, communications are generally protected by confidentiality, but this does not extend to forensic evaluations where the findings are intended for the use of the court. The therapeutic and forensic assessments serve distinct purposes and are guided by different principles and goals. So for the therapeutic assessment, the primary goal is to help the individual improve their mental health and their well-being. It's used to guide therapeutic interventions and support the person's growth. Again, with regard to forensic assessment, we need to be objective, unbiased, and assist the court or the legal system in making decisions. And we address questions related to legal matters and the psychological impact of various different events. So we also need to talk about the therapeutic assessment and how this plays into expert competency. And so when we are thinking about expert competency in forensic versus therapeutic assessments, it involves very distinct skills and knowledge, and these can be very different. So first, let's start off with the therapeutic assessment, and the expert competencies here need to be a deep understanding of psychological theories, diagnostic criteria. Therapeutic techniques are absolutely crucial. This competency involves expertise in diagnosing and treating mental health disorders, and this person needs to have the ability to build a therapeutic alliance, conduct effective clinical interviews, and use various therapeutic modalities. This includes empathy, active listening skills, and providing appropriate interventions based on the client's needs. Whereas we flip over to the forensic assessment, and the expert competency needed there, the expertise in legal standards and procedures relevant to the specific type of forensic assessment being conducted. Again, an example here is risk assessment. We have to have the ability to apply psychological principles and methods within the legal context, ensuring that assessments meet the legal criteria. We're going to talk about this much more in future lectures. We also have to have competency in conducting assessments without bias or personal influence. We need to remain objective throughout the evaluation process. And we also have to have proficiency in using forensic assessments, tools, and techniques that are validated for legal purposes. This includes structured interviews, psychological testing, and being able to analyze legal documents. We have to have skills in presenting findings clearly and effectively in court. This involves explaining complex psychological concepts in a way that is understandable to judges, juries, and attorneys. We also need to be able to produce detailed and accurate reports that are admissible in court. These reports must be thorough, objective, and tailored to address specific legal questions, and we're going to have an entire lecture on how we do this. We also have to have an understanding and adherence to ethical guidelines specific to forensic practice, such as avoiding conflicts of interest and maintaining professional boundaries. We also have to explain the purpose of the assessment and how this information will be used in legal proceedings and any limitations, which there are many, to confidentiality. As we move on here, we're going to look at the nature of the hypotheses tested. So with regard to therapeutic assessment, the hypotheses here are centered around understanding of the client's psychological functioning, their symptoms, and their experiences. And these hypotheses aim to uncover underlying issues that contribute to the client's mental health difficulties. Now, if we flip over to the forensic assessment, these hypotheses are much more legal focused. They are formulated to address specific legal questions or issues relevant to the case. These hypotheses are aimed at providing objective information that can assist the court in making legal decisions. So, for example, a hypothesis might include evaluating whether a defendant is competent to stand trial. So, asking ourselves, was the defendant able to understand the nature of the proceedings and assist in their defense? Or assessing the risk of reoffense, asking ourselves, what's the likelihood of recidivism based on the defendant's psychological profile? We also have to explore level of scrutiny. With regard to therapeutic assessment, there's typically very little scrutiny. Instead, we're just looking at the client's psychological state and making sure that we're providing effective treatment for them. Whereas in the forensic setting, as you can imagine, the level of scrutiny is significantly higher. Forensic assessments are subject to high levels of scrutiny due to their legal context. The findings must withstand rigorous examination in court and meet specific legal standards. The scrutiny involves ensuring the assessment methods, the results, and the conclusions are all objective, reliable, and relevant to the legal issues being addressed. Forensic assessments are also often used. We use standardized tools and procedures to ensure consistency and reliability. These tools are validated for legal purposes and are designed to be objective and replicable. Findings may be scrutinized during legal proceedings through cross-examination by opposing counsel. The forensic psychologist must be prepared to defend their methods, their findings, and their conclusions in court. Detailed and accurate documentation is absolutely crucial. Reports must be clearly presented in the assessment methods, findings, and rationale behind these conclusions, and making sure that they adhere to legal and ethical standards. And the forensic psychologist must maintain impartiality and avoid conflicts of interest, ensuring that the assessment that is conducted and the report that is a consequence is created in a manner that is fair and objective. So next we're going to look at the structure of the relationship, which we've already kind of alluded to this. Within therapy, that therapeutic alliance is built on collaboration and mutual respect, and that is a therapist-patient relationship, whereas when we look at the forensic assessment, this is very much an evaluator-centric and objective role. So the forensic relationship is structured to maintain objectivity and impartiality. The evaluator's primary goal is to gather and assess information relevant to the legal question at hand. and the structure is more formal and structured, obviously, compared to the therapeutic assessment. The evaluator follows very specific protocols and procedures to ensure that the assessment is conducted in an appropriate manner. So the forensic evaluator very much controls this relationship. With regard to the nature of the relationship, the therapeutic assessment is supportive, it's collaborative, there's trust, empathy, mutual respect. It is a helping relationship, whereas within the forensic setting, the relationship is evaluative and objective, focusing on gathering and assessing information for legal purposes. The evaluator maintains a formal, professional stance with clear boundaries and an emphasis on being impartial and transparent, and at times this relationship may even become adversarial. With regard to goals, this is pretty straightforward. The therapeutic relationship is for the client's benefit, whereas the forensic assessment is definitely for the benefit of the court. With regard to critical judgment, we know that this is not in alignment with the therapeutic relationship, and it is likely to cause a rupture between the therapist and the client. Within forensic settings, a forensic psychologist would make it clear from the very beginning of their work together the purpose and the nature, and that there is no expectation of a therapeutic relationship now or ever. If we are transparent from the very beginning, any critical judgment that may arise is less likely to harm the defendant. Moving on to tools, as a forensic psychologist, we rely on lots of different data points and bring them all together to make an informed decision that we will present to the court. Clinical history in forensic psychologists refers to comprehensive collection of evaluation of individuals' past psychological, medical, and social background. This history is crucial for understanding the person's mental health, their behaviors, and how these factors may relate to the legal issue at hand. We are going to talk in depth about clinical interviews and what to include, so stay tuned for that. But just a couple of components for clinical history. We're going to look at mental health history. That's going to be information on past and current psychiatric diagnoses, treatment, hospitalizations, therapy, and medication use. We could also be looking at medical history, physical health issues, neurological conditions, injuries, particularly those that may affect cognitive or emotional functioning. We would be remiss if we didn't talk about substance use history. We need to gather records on alcohol and drug use and any related treatments or rehabilitation efforts. We also want to explore family and social history and the background on one's family dynamics, their upbringing, their relationships, education, employment, and social interactions. With regard to criminal history, we want to gather as much information as we can on past criminal behaviors, arrests, convictions, and any previous forensic evaluations or court-ordered treatments. We are also going to have an entire lecture on behavioral observation, so I'm just going to touch upon it here. But we are going to note the individual's demeanor, their communication, their behavior, and the assessment process. Now we're going to look at adaptive functioning, and these skills are everyday life skills that the individual needs to function independently and effectively in their environment. And these fall into three main categories. The first is conceptual skills. These skills include communication, reading, writing, math, understanding time, and money management. Could also include social skills as one of the domains, and this involves interacting with others, following social norms, problem solving in social situations, and maintaining relationships. And then our third domain here is practical skills, and these are related to personal care such as hygiene, cooking, managing finances, and navigating transportation. So adaptive functioning is essential for managing daily activities and responsibilities across various different environments such as home, school, and work. So as you can imagine, these are going to be very important that we assess whether a person can do these various different things. And then next up is objective and projective assessments. These measures are two very different approaches often used in psychological testing, and they each have very distinct characteristics, purposes, and methods for interpretation. So first, let's talk about objective. Objective measures consider clear, fixed response options such as true or false or multiple choice or perhaps rating scales. An example of this that you're probably familiar with is the MMPI, the Minnesota Multiphasic Personality Inventory, or another example is the Beck Depression Inventory, the BDI. These tests are administered and scored in the same way for all individuals, making them highly reliable and easy to interpret. Objective tests are designed to measure concrete psychological traits, behaviors, or symptoms. The answers are scored objectively using a predetermined scale, making it easier to compare results across individuals. Interpretation is based upon statistical norms and standardized criteria, minimizing bias or individual interpretation. So let's swap over and look at projective assessment measures. Projective assessment tests involve ambiguous stimuli or tasks that allow for open-ended responses. A very famous one that I'm sure you've heard of is the Rorschach inkblot test. Another one that's a little less famous is the thematic apperception test, the TAT. And an individual is asked to interpret or describe what it is that they see in this ambiguous stimuli with less standardized instructions compared to objective measures. Projective tests are designed to explore deeper unconscious processing, motivation, and conflicts that may not be able to be assessed through direct questioning. Responses are interpreted based on themes, symbols, patterns, and interpretation can vary between evaluators, making this process much more subjective. Since the interpretation relies on the evaluator's expertise or theoretical orientation, there is a higher risk for subjectivity. So lastly, here you can see the area for forensic assessment instruments. You're going to have individual videos to watch on the MacArthur Competency Assessment Tool, on the FIT, the fitness interview, as well as the HCR20. So I just listed them here, but we're not going to go into detail about those here today. So let's move on to our specialty guidelines that apply for forensic psychologists. Specialty guidelines for us are crucial because they provide a framework for ethical and professional conduct in the field that deals with complex legal, psychological, and ethical issues. These guidelines ensure that forensic psychologists operate in a manner that is consistent, objective, and respectful in both forensic and psychological principles. We need to ensure competency. So forensic psychology involves specialized knowledge and skills, including understand the legal process, standards of evidence, specific assessment tools, and these guidelines help to ensure that forensic psychologists are adequately trained and competent to handle the unique demands of this particular type of work. These guidelines help to safeguard against unqualified or underprepared practitioners who might inaccurately use assessments or testimonies. The guidelines also help to ensure that forensic psychologists adhere to the highest ethical standards. They provide clear rules for issues like confidentiality, informed consent, and avoiding dual relationships. The ethics in forensic work are especially crucial due to the potential impact on legal outcomes, personal liberties, and individual people's lives. Ethical misconduct can result in harm to litigants, injustice, and damage to the credibility of our profession. Forensic psychologists must maintain neutral and objective manner as their assessments and their testimonies can influence legal decisions like custody rulings, criminal sentencing, or civil lawsuits. The guidelines help psychologists avoid bias and maintain impartiality. Maintaining this objectivity ensures that evaluations are fair and based on evidence, not influenced by personal opinions that the preferences of legal parties or other external pressures could potentially put on us. The guidelines also help to delineate the forensic psychologist's role as distinct from other types of roles, such as a psychologist who is clinical or therapeutic in nature. Forensic psychologists often conduct evaluations for legal purposes and not for treatment, and these guidelines clarify these boundaries. This distinction prevents role confusion, which could compromise the quality of the forensic assessment or result in ethical breaches, such as providing therapy services for individuals who are involved in litigation. Forensic settings often involve different standards for confidentiality compared to the legal setting. We discussed this earlier, so these guidelines help to clarify for psychologists how to handle this confidentiality and inform individuals about all of the various different limitations that are put upon this by the legal context. These guidelines also help to promote consistency across forensic evaluations, ensuring that psychologists follow established standards regarding the specific case or legal context. This contributes to fair legal proceedings, and it helps to reduce variability in assessments, making evaluations more reliable and accepted in the courtroom. These guidelines hold forensic psychologists accountable to professional standards by using oversight by ethics boards and professional organizations, and this accountability is critical for maintaining trust in the profession. This accountability ensures that forensic psychologists who violate ethical standards can be disciplined, protecting both the legal system and individuals involved in cases. By following specialty guidelines, forensic psychologists demonstrate that their work is grounded in recognized standards of practice. It increases the legal system's trust in our expertise and the validity of our assessments and testimonies. Judges, attorneys, and other legal professionals are more likely to rely on psychological evaluations if they are conducted according to established guidelines. So a lot of which we have briefly covered here today. So I'm going to encourage you to explore the specialty guidelines. You can click on the link here and refer to them when you need them. Remember, these are going to be aspirational. We're going to do our absolute best to uphold them, but these do differ in that the APA Code of Ethics for psychologists, those are binding for us. So you also may be wondering when these specialty guidelines come into play, and we answered this earlier, but we'll answer it here again, is that the answer is that the moment the work starts to become forensic, that's when we need to get out these guidelines. So I want to take a look at a few quotes that exemplify this. So first is forensic psychology refers to professional practice by any psychologist working within the subdiscipline of psychology and when applying the specialized knowledge of psychology to assist to the law to assist in addressing legal, contractual, or administrative matters. Another quote exemplifying this is, practice is not considered forensic solely because of the conduct takes place or the product is presented in a judicial forum. Psychological testimony that does not include psycholegal opinions is not ordinarily considered in forensic practice. So next we need to talk a little bit about expert evidence within the courtroom. So let's spend some time here looking at expert evidence in the courtroom. And one of the landmark cases that we absolutely need to talk about is Fry v. United States. And this case took place in 1923. It established the Fry standard for determining the admissibility of scientific evidence in the court. This case involved the admissibility of precursor to the modern polygraph, known as the systolic blood pressure deception test. So let's talk a little bit about the background of this case. In the 1920s, James Alfonso Fry was on trial for second-degree murder. Fry confessed to the crime, but later retracted his confession. To support his innocence, Fry's defense team wanted to introduce evidence from a test that measured his blood pressure while answering questions, suggesting that he was telling the truth. The key issue was whether this early form of polygraph was scientifically reliable enough to be administered as evidence in court. The defense argued that the test results showed Fry was not lying, and the prosecution questioned the scientific validity of this test. Now, the court's decision, the U.S. Court of Appeals for the District of Columbia ruled against Fry, stating that the systolic blood pressure test was not admissible because it had not yet gained general acceptance, quote unquote, in the relevant scientific community. The decision established what became known as the Fry standard for determining the admissibility of scientific evidence. Under the standard, and for the scientific evidence to be admissible in court, the method or principle for which it derived must have gained general acceptance in the relevant scientific community. So the significance of this case was that the Fry standard became the dominant rule for admissibility of expert testimony and scientific evidence in the court for many years. It required that any scientific method used in court be widely accepted in its specific scientific field, This ruling shaped how courts evaluated emerging scientific techniques such as lie detectors, DNA tests, and psychological assessments until it was partially replaced by the Dalbert standard in 1993, which we will talk about, from the Dalbert v. Morel Dow Pharmaceuticals case. So, some limitations with regard to Fry. One major criticism of the Fry standard is that it can be slow to adapt to new scientific advancements. It emphasizes the consensus of scientific community, meaning that novel but potentially reliable scientific evidence could be excluded if it has not yet received widespread acceptance. Now, while the Fry standard has been superseded in federal courts and some state courts by the Dalbert standard, which considers factors like testability, peer review, and false error rates, many states still use Fry as their standard for admitting scientific evidence to the court. So, to wrap it all up, Fry v. United States 1923 set the precedent that scientific evidence must be based on method that has gained general acceptance in its relevant scientific field to be admissible in court. It established the Fry standard, which has shaped the legal treatment of expert testimony and scientific evidence for decades. So as we move over, we look at the 702 rule of the Federal Rules of Evidence established in 1975. This is a critical rule governing the admissibility of expert testimony in federal courts, including testimony provided by forensic psychologists. Rule 702 was designed to ensure that only qualified experts offer opinions based on reliable methods and relevant information. It is directly relevant to forensic psychologists when they provide expert testimony in legal cases. So some key components of this rule is that as the expert witness, that is the forensic psychologist, they may testify in court if the witness is qualified. So the expert must have the knowledge, skill, experience, training, or education to qualify as an expert in the relevant field, such as forensic psychology. The expert's testimony must rely on sufficient credible facts or data, ensuring that opinions are grounded in reliable information relevant to the case. The expert must use reliable and established principles and methods in forming their opinion. This ensures that testimony is scientifically valid and not based on speculative or untested methods. The expert must demonstrate that the case has applied their methods in a reliable way to the facts of the specific case at hand. Now, forensic psychologists who have provided expert testimony on issues such as mental competency, risk assessments, criminal responsibility, and psychological evaluations must adhere to Rule 702 to ensure their testimony is admissible in court. Now, a forensic psychologist must demonstrate the appropriate training, experience in forensic psychology, which is distinct from other areas of psychology as we've discussed. The forensic psychologist must use widely accepted methods in psychology, such as validated psychological assessments and interview tools, and base their conclusions on sound evidence-based facts and practices. And the forensic psychologist must show their conclusions were derived through a careful and reliable application of these psychological methods to the specific circumstances of the case being tried. So the evolution of Rule 702. In 1993, the Dalbert v. Merrill-Dow Pharmaceuticals case was modified and how Rule 702 was applied by creating what is known as the Dalbert standard, and we're going to cover this next. Now, this new standard emphasized additional factors such as whether the expert's methods can be tested, whether the methods have been peer-reviewed, and whether they have a known error rate. So after Dalbert, Rule 702 was amended in the 2000s to incorporate these rigorous standards for admissibility. So let's dive in a little bit more into the Dalbert case. This is one of the most significant cases in U.S. legal history concerning the admissibility of expert testimony and scientific evidence in court. It established that is the known Dalbert standard, which provides a new and more rigorous approach to evaluating the reliability, the relevance of expert testimony, particularly with regard to scientific evidence. So just a little bit of background. The case involved two minors, the Dalbert children, whose parents sued Merrill-Dow Pharmaceuticals. The plaintiffs claimed that the drug Benedictine was prescribed to pregnant women to treat morning sickness, caused birth defects in their children. Morel-Dow expert witness provided studies showing no link between Benedictine and birth defects. The plaintiffs, however, presented their own expert testimony, relying on unpublished studies and methods that had not been generally accepted by the scientific community. The trial court excluded the plaintiffs' evidence, citing the Frye standard, general acceptance in the scientific community. Then the U.S. Supreme Court ultimately ruled in favor of the plaintiffs, overturning the Frye standard for admitting scientific evidence and establishing the Dalbert standard. The court ruled that federal judges under Federal Rule of Evidence 702 should act as gatekeepers to ensure that all expert testimony is both reliable and relevant, rather than just relying on the general acceptance test established in the Frye case. The Dalbert standard outlines several factors that judges must consider when determining whether scientific or expert testimony is admissible in court. First, the theory or technique must be testable and capable of being scientifically investigated. In other words, can the scientific method be applied to test whether the expert's claim is valid? Also, the methodology or theory should have been subject to peer review or publication. Peer review is a critical process in science that ensures that the methods and conclusions of a study are critically evaluated by other experts in the field. The court should also consider the known or potential error rate of the scientific method used. This involves examining the reliability and precision of the method or technique. The technique should also be governed by standards and controls to ensure its consistency and reliability. Are there established protocols to ensure this accuracy? So while the factor is similar to the Frye standard, under Dalbert, general acceptance is just one of many factors. Even if a theory isn't widely accepted, it might still be admissible if it satisfies other criteria. So let's talk about the significance of the Dalbert case. The Dalbert standard replaced the older Frye standard, which focused solely on whether a scientific method or theory was generally accepted in its field. The Dalbert ruling provided a broader, more flexible approach, ensuring a new scientifically valid techniques that hadn't yet been gained widespread acceptance could still be admissible. The case emphasized the role of federal judges as gatekeepers who must scrutinize expert testimony to determine its scientific validity before allowing it into evidence. This put more responsibility on judges to evaluate the underlying methodology, not just on the expert's credentials. Dalbert had a significant impact on the admissibility of expert testimony across various fields, including forensic psychology, as well as medical sciences, and engineering courts became more cautious and required more significant rigor in the methods used by expert witnesses. Although initially focused on scientific testimony, the Dalbert ruling was later extended to include other forms of expert testimony, including fields like engineering, psychology, and even economics, making it a standard for evaluating all types of expert evidence. While Dalbert applies to federal courts, many state courts adopted this standard, moving away from the Frye standard. This made the Dalbert influential beyond just federal litigation. Dalbert was in the first of a series of cases dealing with expert testimony, following several others such as the General Electric Co. v. Joyner in 1997 and Kumho Tire Co. v. Carmichael in 1999, which further redefined the roles of judges in assessing expert testimony. So to wrap it all up, the Dalbert v. Morel-Dow Pharmaceuticals case in 1993 reshaped how courses evaluate the admissibility of expert testimony, emphasizing the need for scientific validity and reliability. It replaced the Frye standard with a more comprehensive approach that considered various factors like testability, peer review, and error rates, while assigning judges the role of gatekeepers. The Dalbert standard has had a lasting impact on forensic science, psychology, and many other fields, ensuring that expert testimony in U.S. courts is held to a higher standard. The Dalbert case created many ripples in how these cases were examined. Like we just talked about, the trial judge is the final arbiter or the gatekeeper, and the judge has to consider some questions such as, what is the basic theory and has it been tested? Are there standards for controlling this technique? Has the theory or technique been subjected to peer review and publication? What is the known or potential error rate? Is there general acceptance of the theory? Has the expert adequately accounted for alternative explanations? Has the expert unjustifiably extrapolated from an accepted premise to an unfounded conclusion? So, jury vetting of reliable evidence is facilitated by rigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof in order to make sure that the expert testimony is up to par. So we are going to move on now and talk about psychologists' responsibilities before we wrap up here for today. We are responsible for avoiding conflicts of interest, such as dual roles. This is going to be a big one. The dual role for forensic psychologists occurs when they serve in two conflicting capacities, potentially compromising their objectivity or professional boundaries. So an example here would be a forensic psychologist is hired by a court to assess a defendant's competency to stand trial. After completing that evaluation, the psychologist is later approached by the defendant's attorney to also provide therapy to the defendant while they await trial. In this scenario, the psychologist is placed in a dual role because they are both the evaluator for the court, so objective and impartial role, as well as being asked to be the therapist, a supportive, confidential role. These roles conflict, and as a therapist's duty is to prioritize the client's well-being, while the evaluator must remain neutral and objective, potentially providing testimony that could harm the client's legal standing. This situation can lead to ethical violations and is discouraged by forensic psychology guidelines. Next up, we want to avoid iatrogenic harm, such as creating a false memory. And this refers to intended harm caused by a healthcare professional, their treatment, or their intervention. And in the context of forensic psychology, iatric harm occurs when a psychologist's actions or evaluations inadvertently cause psychological, emotional, or legal damage to the individuals involved in the legal proceeding. This harm can result from improper assessment techniques, biased evaluations, or breaches in ethical guidelines. So let's talk about a few ways that we can try to mitigate this. If a forensic psychologist conducts an evaluation using inappropriate methods or faulty assumptions, it could lead to false conclusions. For instance, diagnosing a defendant with a mental disorder they do not have could influence the court's decision negatively, affecting the individual's rights and their potential legal future. A psychologist might unknowingly cause distress during interviews or assessments by revisiting traumatic experiences in a manner that re-traumatizes the individual without providing the necessary support or debriefing after the evaluation. Also, when we think about family case law, specifically custody evaluations, biased or inadequate assessments could lead to the wrong parent receiving custody, potentially harming the child's well-being and family dynamics. So ways that we can avoid harm is that we want to follow ethical guidelines. Those put forth by the American Psychological Association ensures that the forensic psychologist maintains professional boundaries, avoids dual roles, and respects the dignity of individuals being assessed. Forensic psychologists must remain objective and avoid personal biases that could skew the evaluation. This involves relying on scientifically valid assessment methods and being transparent about the limitations of their conclusions. Forensic psychologists should use evidence-based assessment tools and methods that are widely accepted within the forensic psychology, the psychology, and the legal community to ensure accuracy and minimize the risk of harm. Psychologists, again, we must explain the limits of confidentiality to individuals being evaluated, especially in forensic contexts where information may be shared inside the courtroom. This helps individuals understand how the information will be used and mitigate potential feelings of betrayal or harm. Again, circling back to the top here, if we avoid conflicts of interest in dual roles, acting as both, for example, the evaluator and the therapist for that same person, this helps maintain objectivity and prevent harm by causing conflicts of responsibilities. After assessment, especially those that delve into sensitive or traumatic topics, forensic psychologists should provide adequate debriefing to ensure the individual has access to appropriate support if needed. Regular training and staying updated on the latest research and ethical guidelines for forensic psychologists helps us to avoid outdated practices that could unintentionally cause harm. By remaining objective, ethical, and evidence-based, psychologists can minimize the risk of causing harm and ensure their work supports rather than undermines the legal process and the individuals involved. Again, we need to make sure that we are working squarely within our area of competence. If we work outside of our area of competence, this is something that we absolutely should not be doing. So a few ways that we can kind of keep ourselves in check is self-awareness is going to be key. As a forensic psychologist, we must first acknowledge when a particular task, assessment, or issue falls outside of our scope of expertise, knowledge, or training. If this does happen, the psychologist is found to be non-competent to handle a specific matter. They should refer the case to a qualified professional who has the necessary experience in this area. For instance, if the issue involves a specialized area of law, for example, child custody cases or a specific mental health condition, perhaps a rare disorder, a psychologist should identify and recommend someone with the appropriate expertise. If it's feasible to gain the necessary competence through supervision or consultation, the psychologist may work under the guidance of a more experienced colleague who has expertise in this field or area, and this can be appropriate if the issue is within the reach of the psychologist's broader competence and they can gain enough guidance to handle this responsibility. If the issue is recurrent or relevant to their future work, the psychologist can seek additional training or education to develop this competency area. However, this should not happen during the course of a case. Competency must already be established before engaging in a professional task. The psychologist should disclose their limitations to the court or the parties involved. Transparency is essential, especially in legal settings where the psychologist's opinions and testimonies carry significant weight. If the psychologist proceeds without full competence and fails to disclose, it can lead to ethical violations and professional consequences. If competence cannot be quickly achieved or the situation is too specialized, the psychologist should decline the task or the case altogether. Taking on a case without the necessary competence can lead to harm, legal consequences, or damage to the credibility of the psychologist's work. So, according to the American Psychological Association's ethical principles, as well as the specialty guidelines for forensic psychology, competence is the core ethical requirement. Acting outside of one's competence is considered unethical and could result in harm to clients, improper legal outcomes, and damage to the integrity of the psychologists in the field. In forensic settings, psychologists' evaluations, testimony, and reports can significantly impact legal decisions, so it is vital that these be grounded in professional expertise. Next up is informed consent. We must obtain informed consent. This is going to be crucial for forensic psychologists for several reasons. And first of all, informed consent is a fundamental ethical principle with respect to an individual's right to make knowledgeable decisions about their participation in psychological evaluations or interventions. It ensures that individuals are fully aware of and understand what is involved, as well as transparency, and this involves providing clear and comprehensive information about the nature, purpose, and potential consequences of the assessment or intervention. This transparency helps prevent misunderstandings and ensures that individuals' participation is based on a clear understanding of what to expect. Obtaining informed consent protects both the individual and the forensic psychologist legally. It ensures that individuals' agreement to participate is valid and that they are aware of their rights and the purpose of the assessment and how that information will be used. In legal context, properly obtained informed consent can be crucial for the admissibility of evidence. If consent is not properly obtained, the findings or testimony could be challenged or even excluded in the court. Forensic psychologists must explain how the information obtained will be used, including its potential impact on legal proceedings. This helps prevent misuse or misinterpretation of data and ensures that the individual understands the implications. Informed consent includes informing the individual about the limits of confidentiality, particularly in forensic settings where information may be shared with the court and other third parties. This clarity helps manage expectations and reduces the risk of breaches of trust. Also, clear communication when obtaining informed consent can foster some trust between the forensic psychologist and the individual, and this trust is essential for effective evaluations and helps to ensure cooperation and openness during the assessment. By ensuring that individuals are well informed, forensic psychologists minimize the risk of causing emotional and psychological harm due to misunderstandings about the process or its outcomes. Informed consent also ensures that participation is voluntary. This is going to be difficult here for us within the forensic realm. However, we do want individuals to understand that they have the right to refuse or to withdraw from the evaluation or the intervention at any time without negative consequences. And this helps to prevent coercion or undue influence, ensuring that individuals are participating based on their own informed choices rather than any type of external pressures. And this is going to be very important as we are working within the legal system. So lastly, this bullet point down here is all about duty to warn. Duty to warn refers to the obligation of a psychologist to alert potential victims or authorities if they have credible information that a client or patient poses a serious risk of harm to themselves or others. This duty emerged from the landmark case of Tarasoff v. Regents of University of California in 1976. In this case, the therapist's failure to warn a potential victim about a threat made by a patient led to the victim's death. The court ruled that the mental health professional had a duty to warn individuals who are at risk of harm based on threats made by their clients. When a psychologist learns that the client intends to harm a specific individual, they must take reasonable steps to warn the potential victim or inform law enforcement. This exact requirement can vary by jurisdiction. That's why it's important for you to know where you are and what your particular state or jurisdiction's duty to warn and duty to protect statutes are. So on the other hand, we have duty to protect. This encompasses broader responsibilities beyond merely warning. It involves taking proactive measures to prevent harm, including intervene to protect potential victims or ensuring that the individual posing a threat receives appropriate treatment. Psychologists must assess the level of risk posed by the individual and determine appropriate interventions. This may involve notifying authorities, arranging for emergency psychiatric evals, or implementing other protective measures. Psychologists may collaborate with other professionals, such as law enforcement or other mental health services, to ensure adequate protection and intervention. And this duty often requires psychologists to balance confidentiality and the need to prevent harm. They must carefully navigate the legal and ethical considerations to protect potential victims while respecting the rights of individuals who pose a threat. Okay, so just as a recap there, duty to warn requires psychologists to alert potential victims or authorities if there's a credible threat of harm posed by a client, whereas duty to protect involves proactive measures to prevent harm, including assessing risk, intervening, and collaborating with other professionals. All right, so it's important to note a few points here with regard to data collection and analysis. Where the science stops, so do you. Do not go beyond what it is that the data tells you. Always, always, always use current best practices and stay abreast of those, which you can find out through simple Google searches, having subscriptions to journals, going to conferences, talking to colleagues. All these things are ways that you can stay abreast of the research. This goes hand in hand with correct administration. There are very specific administration protocols for a reason, and this is to ensure consistency and reliability and fairness. Always use tests that are appropriate and normed for your particular examinee. If the norms don't fit, it's not going to be a good test for you to use in your battery. Rely on your clinical tools, such as your protocols, your handbooks, your manuals, to properly interpret and report psychometric data. Report everything, both confirming and disconfirming data. We want to be truthful without being biased. And just be aware that session notes can also be discoverable as well. So as we're starting to wrap up, we just want to talk about how important it is to maintain testing integrity. It is an ethical violation to release raw data, answer sheets, stimuli, and manuals. We have to protect these. If the ethics standard is stricter than the law, psychologists are obligated to follow ethical standard. So I'm sure y'all have taken ethics classes, but as a reminder, if the law and the ethics code conflict, a psychologist is obligated to make known the conflict and to take steps to resolve the conflict in a reasonable manner. So some questions that you may want to ask yourself is the demand for disclosure legal? If it's not, stop right there. Some ways that you could approach this dilemma include writing a letter to the court, a legal motion to be relieved of the demands. In the rare case that you can't resolve it, you may follow the law without being in violation of your ethics. So always seek consultation and supervision if you feel like you need it. And as the guidelines tell us, we should discuss fees up front. We never work on a contingency fee basis. We, as forensic psychologists, must remain true to our ethics and cannot be purchased for a bias assessment, result, or outcome. So I know, again, this was a lot of information. Thank you for listening. I know that you're going to learn a lot this semester, and I'm really excited to be the one to share this information with you.